Ladies and gentlemen, I would name this Conference of Plenty. Plenty of nice people, big thoughts and delicious food. Thank you very much. I will take away. My presentation is about how not to do things. I think in 50 minutes, I start counting, I can do only one thing, and that's let's simplify, let's see how not to do things. We will start with a history, a little bit, then move on to the second codification process in the Czech Republic, and I prepared 5 cases, law in action, but I'm afraid I will have time only for 3 of them. Czech law was codified in the 60s of previous century. Of course, we speak about country, about totalitarian regime. The code was prepared for central economy, and of course, society was controlled by the party. No one thought after the coup that the law can survive. Unfortunately, it was not later than 2006 when the legislator decided to change the world. The legislator decided to do 2 things at the same time. Because of certain, let's say, social climax or cohesion, the legislator had to ensure voters that the same level of protection will be guaranteed. At the same time, because short room of maneuver, short or limited narrow flexibility was what entrepreneurs, what managers claim what was not done in the first Czechoslovakian code. That was the main objection, that almost all rules are mandatory and contracting parties don't understand. They don't know in advance what can be arranged in different manner. Therefore, the main, let's say, goal for the legislator was to increase level of flexibility. I'm just mirroring 2 main, let's say, borders, 2 main lines of protection. The first, which rules are mandatory. The legislator developed 9 definitions. 9 definitions. I'm not going to even read them, because the problem was that there were certain definitions, sub-definitions, interdefinitions. Simply it was weak, ambiguous. And that was the conclusion of the Constitutional Court, that in this way the legislator hamper legal certainty. Too many definitions. We can see mistakes of legislation in more simplified example. From the 3rd amendment to Austrian General Civil Code, in Czech law, it's something what is called mandatory rules that could be where or in which the employee can decide to waive protection. Relatively mandatory rules only for the employers. And the Czech legislator decided, I have to do a list of all rules which implemented EU directives. That was section 363. And because there is a list anyway, I will use the same list to enumerate all rules that can be used as relatively mandatory, that can be departed from on the will of the employee. The problem was that you can find there, for example, protection of pregnant women. And when we saw it in the language of the law, we asked, hey, can pregnant women be get rid of because she just waived her protection? Can be dismissed because she's pregnant and she's willing to be dismissed? Does it make any sense? And that is at least such short, simplified picture of misunderstanding what does it mean to be flexible. The second example is a doctrine of delegation. We are speaking about room of maneuver for civil law. To what extent civil law, civil code can be used in labor law relationships. I think that history is full of irony because the previous section 4 of the second Czech code enacted the rule that only set of rules enumerated by the labor code can be used, and to the extent as specified in the labor code. The same problem, the problem of 2007. We have identified that the legislator omitted certain important rules of protection for employees, or mentioned some additional rules which are not so fundamental to labor law. And that makes people think, can I apply or not? The Constitutional Code of Czech Republic abolished Section 4, and in one subsequent amendment, the legislator implemented the rule of, let's call, subsidiarity. What does it mean? Civil law is applicable to the extent it doesn't violate fundamental labor law principles. Of course, it was derived by the Constitutional Court, and in more or less 1 year it was enacted by law. In last 7 minutes talk, my speech is about subsidiarity, is about flexibility. From the beginning of 1965, from the very first Czechoslovakian code, there was, or we can think about it as the second-class employees. Employees with low protection, with almost no protection against dismissals. Employees with limited entitlements to payments for bonuses. And again, it was developed by the totalitarian legislator in 60s of previous century and has never been abolished. We call them work agreements. Oddly enough, the regime changed, reasons were somehow changed as well, but those agreements are still there and they are in huge demand. They are used for different reasons, but they are used. And that can be understood as our way how to make workforce flexible, how to make people flexible. I can use these agreements. They are there from 1965. That's one picture of flexibility as done by Czech legislator. Of course, we can speak about reasons, but now I guess for just a brief outlook into Czech law. The second from my 3 examples is fixed-term relationship or chain fixed-term contract. In the previous regime, if I could simplify it, it could be used up to 2 years. Today, for civil servants, there is no cap, there is no upper limit. They can be non-permanent for unlimited period of time. They can be appointed for 7 years, 7 years, 7 years, 7 years. That's state servant law. Under Czech labor law, this set of rules has been amended almost in every crucial amendment. It has been changed 7 times, at least, or if we count in the last 8 times. Today, our employees can be up to 9 years non-permanent, and there are two additional exceptions. For example, the guy who killed in close to Hungary, there was mass shooting in Czech Republic. He was fixed term 25 years, killed 8 people. It can, of course, we don't know. It can have certain impact, but definitely speaking about flexibility, non-permanent employees is something that has been increased after 1989 and is again in huge demand. And maybe the last example, my last example goes to my distinguished colleague from Croatia, and I'm speaking about collective employment law. Czech Republic, at that time Czechoslovakia, decided to use Dutch law. We have Dutch law from 90s of previous century on the scene, and it doesn't work. That's one example that you can adopt law from different country, but if the informal structure is different, it won't be a good thing. So we have strikes under Dutch law, and there are strikes on the Dutch law basis, but there are other strikes, at least 50 of them every year, and they are completely without any sort of legal basis. And the government tried 3 times, but has never been successful to implement any sort of legal foundation of strike law. Strikes in the Czech Republic are done on the basis of constitutional law, but in the constitution, if you go there and you look for right to strike for these economic or social rights, you will find that it can be based on statutory law. Ladies and gentlemen, the short conclusion. I think that the mixture of flexibility and security as handed by Czech legislator in last 20 years, it's a disaster. It doesn't function well. What we can say, what can be done and what is done are particular amendments, changes to particular set of rules done either by courts. Although we are a civil law country, there is judge-made law in the Czech Republic. That's one story. And the second story, simply the will of social partners can create a flexible legal environment. Thank you very much for your attention.
So anyway, I had to cancel, but instead of Paris, I had to examine the state exam week in my university. So anyway, the point is I'm here now, online, and apologize for my such kind of, seemingly outsider, but I'm with you. So anyway, my short presentation, short Corefferatum is going on some kind of peer review. So I got the text of an excellent text of Professor Martin Štefko, and I read it, and like a small schoolboy, I started to study the Czech labor law, what happened in the last couple years. So that's why my presentation or my remarks relating to the Czech point of view. So I'm not compared to the Hungarian situation, I'm not compared to any other situation. By the way, to my Polish colleague, I would like to send a message. This is not my task about this kind of issue which one he raised about graduate internship contract, but this is beyond this. Okay, so anyway, I divide these three parts very quickly. First, I analyze the structure of the paper. But before, I wanted something here. This is a suggestion for the organizing committee. So maybe right now, for the future, right now we are concentrating on individual labor law, individual employment contract, or whatever we call. Second is collective contract or collective bargaining contract. So, due to the fact that we are dealing with COVID and some other European influence, perhaps in the future we can expand the examined fields to the third field of labor law, which is mainly relating to the state. This is labor administration in one hand. On the other hand, it also came up when I was listening to these lectures or presentations. In social law, it's a fact that we are making some kind of differentiation, a constitutional approach of social law and some kind of labor law issue of employment, so or social security. So maybe here also we can start to make distinction between the labor law approach and labor and employment approach, and there is some kind of constitutional. So anyway, the first part I don't want to repeat. The paper is precisely dividing three parts. One is the dogmatic parts. It was mentioned partly by my colleague Martin Štefko. The second is the current labor law issues. This is dedicated mainly for COVID. I will come back. I will give some kind of perhaps suggestions or some thought. This part mainly concentrating on the administrative issues, testing, vaccination, temperature measurement, and so on and so on. And there is a quite long subchapter which is dealing with the volunteer firefighters. This is not clear for me. Even I read 2-3 times the paper, why you paid a lot of attention for this kind of volunteer firefighters is a little bit beyond the logic, beyond such kind of big amount of text, relatively big amount of text. And after there is the third issue. This is European influence. That is also, I will suggest, if I will have time, because mainly this subchapter is dealing with the working time directive, the dichotomy and the problems of working time directive, and conclusion. So the second part of my analysis, this is completely in line what you have already said in this presentation, which is partly beyond the text which one was submitted, at least to me. So first, influence of, I found 3 influences from your text on Czech labor law. One is the historical. This is mainly the German style influence, and today you mentioned the paper does not contain about this kind of socialist inheritage, let's say inheritage, and this kind of civil and labor law, civil law and labor law dichotomy, which one you discussed. The second influence which I found and extracted is the EU supranational legislation, and as I said, is very tiny. A piece of the European legislation comes back in your paper. And the third one is COVID-19. So the third part of my analysis, which one I put some kind of title, is what is missing for me. There are some questions following the logic, the structure, which one I said before: dogmatics, current labor issues, European issues. So as a general issue or a dogmatic part, you mentioned under paragraph 1.2 the different kind of representation, workers' representations, and mainly you just mentioned the Works Council. And for my, from my, and trade union is discussed a little bit more longer. From my point of view, since this kind of First Council exists from 2001, it had some kind of very special, I read in different books, a special history. It was some constitutional court cases in 2008. So anyway, this is, how to say, even though it's not a significant, but maybe more than a half sentence should be mentioned. The second, relating to this general part, I did not understand exactly under paragraph 1.3. I'm quoting now, the contract is a legal act which may be establish an employment relationship. However, the employment relationship may come into being also second way, the employer may appoint the employee. Perhaps the second way, this is what you explained today, but anyway, I would like to highlight for a lay readers, such kind of things is a little bit hard to understand. Also, I have some remark on paragraph 131. This is also unclear for me. The labor, I'm quoting, the labor code sets for that employer but not employee shall contract in writing. So how does it in a practice? Or this is only one-sided, only the employer is obliged. The second, this is a very practical and very, to say, formal remark. Sometimes you miss the so-called unsexist language, to use unsexist language. So I would like to, some part of the text you do, some parts you don't. Okay, the next is under paragraph 1.4, the new labor code guiding principle. You are saying the freedom of contract, everything is possible, what is not prohibited by the law. So in the text, I would like to know, I didn't find whether this kind of statement, this kind of principle is applicable both for a private, not private, for a individual employment contract only, which is the text is saying so far, that one, and or for a collective agreement as well. Also for me was a little bit confusing, maybe I didn't read enough. You also referred to some kind of dichotom, two-sided or two-sourced constitutional source. One is Constitution itself, and the second one is a Charter of Fundamental Rights and Freedoms. It seems to me that is also from the Czech, or I don't know. So this is not clear for me how this kind of two systems, constitutional-like system comes together. Just speed up my contribution. And the second part is COVID and employment or labor enhancement relationship. In the paper, according to my understanding, your focus point is mainly on administrative, employment-related administrative tasks, how to measure the temperature, what kind of prohibition exists, and so on and so on. When I read in different sources, I found some kind of very relevant and very important additional information. Of course, outsiders can say easily, you should deal with that and something. So this is completely up to you. So the first group, which one I found, this is which might be important when we are talking about labor law and COVID. The first one is I called it the state aid programs. One is the first one, the antivirus program, which one is introduced at the beginning of COVID-19 until the end of June 2021. So this was the first, how to say, preliminary action by the state relating to the employment, relating to the labor market. And the second is, which is known, I think, almost all of these countries, the so-called, forgive me my German pronunciation, Kurzarbeit. This is actually the partial employment under ILO Convention 168. So this was introduced 2021 July, and until, if I'm right from my readings, until this year, 2022 February. So this is also, how to say, kind of state aid programs, which one is inspired by the COVID. And the second issue, I called it COVID-19 allowances. So the Czech government introduced different kind of allowances, which is relating to employees who are not able to take part the employment because of this COVID disease. One is the so-called extraordinary quarantine allowance. This is dedicated directly for employees who are under this restriction due to the COVID. The second is the crisis care allowance. This is a care for the family members or surrounding close relatives who are staying at home, and the employee must stay at home. This is kind of care allowance or something like that, but this is due to the COVID. And the third one is the so-called compensation bonus. Compensation bonus, this is mainly for self-employed or self-employed-like employees. So this is the second group. And the third group, which one I found interesting and some of the paper reflected, this is, I called it a new world of work, remote working models. So basically, according to my understanding, this is electric work or e-work or telework or whatever we can call. So according to my readings from the Czech papers and articles, there is somehow nominated two types of such kind of atypical work. This is a home work. Forgive me, maybe this is not a proper translation, but I found it in the English written Czech article. Homework and home office. So there is distinction between. So that might be interesting for readers. Also, there is a reference due to the COVID. Maybe this is only one positive side of the COVID, such kind of digitalized or this kind of remote work enhanced. The second is the job sharing issue, which is inspired also, at least the article said. The third one is that is kind of interesting. I'm honestly speaking, I've never heard about this before. This is work from home travel. Work from home travel. So this is applies for remote workers with more than one workplaces. So this is quite interesting. And the fourth influence made by COVID, this is digitalization and e-signature, like in many countries, and due to the fact that the European Union is trying to force from 2016 this kind of digitalization, there is some kind of, how to say, big step ahead with this digitalization and e-signatures. And the fifth song, which I indicated here, digitalization and employee monitoring. Employee monitoring, so it means the different branch is not a labor law, it's a public law, some kind of data protection, privacy protection. Privacy is not a public, but anyway, privacy, personal protection, personal right protection, and so on. And the third one is, I'm trying to be very, very brief, the EU influence. This is not a big surprise that the EU member state has a lot of influence from the different kind of supranational labor issues. And here, I think we have to mention two things. One is this kind of digitalization program, which is correspond with the COVID-19, but is going beyond and behind and beside and whatever you can. And the second issue, which one should be mentioned here when we are discussing such kind of things, because new or renewed or refreshed directives are coming out. These are so-called European pillars of social rights, which dates back in 2017. But, of course, there are many, many steps from there. I would like to mention only the Porto Social Summit from last year. So this kind of European Pillar of Social Rights, the 20 basic issues, contain several employment-related issues, and many new directives are coming and were coming out from the supranational level,
like the platform work, the whistleblowing, the work-life balance, and so on and so on and so on. So anyway, somehow what you mentioned about influence, this European influence in your paper is the Working Time Directive, and later on a little bit this kind of TWA, the Temporary Work Agency directive. So maybe don't make so big the text, because I think you have a limit, but anyway, a little bit more comprehensive, more focused, but should be a little bit more wider view about this point. Thank you very much, and I would like to congratulate for your excellent paper. I learned a lot, so it was very worthwhile to read. Thank you very much.